Hey guys, this is VJ Dinakar. Today I want to talk about civil harassment restraining orders in California. First of all, what is a civil harassment restraining order? It allows a person to get protection against another person if that person's harassing them. And who qualifies or who can file a civil harassment restraining order in California against somebody else? Well, any person, any adult, and in fact, any minor that has guardian ad litem representation, if they're under 12 years old, can file a civil harassment restraining order in California against someone else, unless that restraining order is more appropriately filed as a domestic violence restraining order. And I've made a few videos about domestic violence restraining orders and who's covered under those. But basically that covers any spouse, former or current cohabitant, or former or current boyfriend or girlfriend, or anyone related by blood or marriage to the second degree. That would be the appropriate forum. That's a family court that you would file a restraining order against somebody, not the civil harassment restraining order. Additionally, there's a workplace violence restraining order that can be filed in California that you may want to file as opposed to filing the civil harassment restraining order. The civil harassment restraining order statute in California is found in California Code of Civil Procedure 527.6. And that statute specifically defines what harassment is. And specifically, in general, it is any violence, any threat of violence, or any other form of harassment that involves a course of conduct. And I want to specifically actually read the exact words in that statute so you'll understand. The statute defines harassment as unlawful violence, a credible threat of violence, or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses that person and that serves no legitimate purpose. The course of conduct must be that which would cause a reasonable person to suffer substantial emotional distress and must actually cause emotional distress to the petitioner. So that statute's kind of a mouthful, but basically what it means is you can get a civil harassment restraining order for any violence, which includes any pushing, shoving, hitting of any kind, any threat of violence, or any conduct that alarms, annoys, or harasses you and causes you substantial emotional distress. So the third category, which is kind of vague, some examples of that could be extreme verbal abuse, which is repeated, unwanted communication. So stalking you. If you are continuously contacted by someone, you tell them you don't want to be contacted, or either the nature or the number of contacts is annoying to you, you can get a civil harassment restraining order for that. So after you file a civil harassment restraining order, there will be a hearing date set at which there might be a trial. And at that trial, I want to give you kind of an idea about what might occur. Unlike even a domestic violence restraining order trial, or certainly a criminal trial, the rules of evidence and what you can introduce, whether you're the responding party who's had a restraining order filed against you, or you're the petitioner and you file a restraining order against somebody else, you can introduce hearsay documents, affidavits that are written where the person is actually not testifying. There can also be live testimony. And the standard of proof is clear and convincing evidence, which is actually a little bit higher than the normal civil standard, which is preponderance of the evidence, but it's a little bit lower than beyond a reasonable doubt, which you have in criminal court. Now, the benefits of getting a civil harassment restraining order are, first of all, you have peace of mind that if you file a restraining order against someone and the court grants it, you are protected from that person, because if that person contacts you or comes within a restricted distance, which typically is around 300 yards, you can immediately call the police and that person will be arrested because their name will be in the CLET system, or the California Law Enforcement and Telecommunications System. And all they have to verify are two things. One, that they're in the system, and that two, that they've been served a copy of that restraining order, and they will be arrested. And so when you file a restraining order against most people, that really deters them from contacting you or coming anywhere near you. So it has just a deterrent effect, and then that provides you substantial peace of mind by filing this restraining order. So what if a restraining order is filed against you? Are there any downsides to a restraining order? It is a civil matter, it's not criminal, but should you just ignore it, or is it something worth fighting? The answer is you really should not ignore it. It is going to be, like I said, in the law enforcement database, it will be in your background check. And in theory, employers could care about it and it could affect you. It's a public document that anyone can really find. It could also, in theory, have immigration consequences. So it's something that you are not going to want to just ignore, because that restraining order, once granted, will last for a few weeks until the hearing. But if you don't show up to court, that restraining order can be granted for a period of 5 years. And then after the 5 years, it can be extended another several years. So you certainly don't want to have that on your background check. Now, if you're filing a restraining order, or a restraining order is filed against you, should you hire an attorney? The answer is you don't have to, and I will say that most civil harassment restraining order matters are matters that do not involve an attorney on either side. Having said that, if you are the petitioner filing a restraining order, or the respondent, and someone's filed a restraining order against you, you really are given a very substantial advantage if you have an experienced attorney fighting for you who knows and understands the law. First of all, the judge will take your case more seriously because they understand that there is an attorney who understands the law that's going to make the judge stand firm to the case law, and not just have the court operate in sort of a kangaroo type fashion, which unfortunately often happens in these civil restraining order harassment cases, because the court has so many of these cases in their docket that they often like to dispose of these matters in 5 or 10 minutes. When they have an attorney, the attorney will usually estimate that the case will be, a case that will last at least a few hours, if not a day or two. And a judge will take that case much more seriously. You do have a better shot. Now, if you are the prevailing party, whether you're the one filing the restraining order as the petitioner or the respondent, you're defending the restraining order, and you win, you prevail, the court will order that the other side pay for your attorney. So that's another reason why, if you're going to be taking this case seriously, you probably want to hire an attorney. I'm going to be making more videos about civil harassment restraining orders. If you have any other questions about civil harassment restraining orders in California, visit me at vjlaw.com. Take care and all the best.